Good afternoon, dear colleagues and guests. Allow me to consider open the meeting of the Dissertation Council for the Defense of Orlov Gerasim Nikolaevich for the degree of Law on Specialty 120003 Civil Law, Commercial Law, Family Law, Private International Law on the topic Option Contractual Structures in the Civil Code of the Russian Federation and Further Development. According to the order of St. Petersburg State University from the 17th of May 2019, number 5153/1, me, Petrov Dmitry Anatolievich, Doctor of Law, Associate Professor of the Department of Commercial Law of St. Petersburg State University, was appointed the chairman of this Thesis Council, and also allow me to introduce my fellow board members. Makarova Olga Alexandrovna, Doctor of Law, Associate Professor of Commercial Law of St. Petersburg State University. Andrei Vladimir Konstantinovich, Doctor of Law, Russian University of Justice. Andreevna Lyubov Vasilievna, Doctor of Law, Moscow State University of Law, named by Kutafin. Suleimanov Maidan Kutuarovich, Doctor of Law, National Academy of Sciences, the Republic of Kazakhstan. And first of all, I would like to emphasize that according to the federal law of the 23rd of August 1996, number 127, Federal Law on Science and the State Scientific and Technical Policy, St. Petersburg State University has the right to independently award academic degrees. The corresponding order on the procedure for awarding academic degrees at St. Petersburg State University, on the basis of which we conduct our meeting of the Council, was issued on the 1st of September 2016, number 6821/1. In accordance with this order, the meeting of the Dissertation Council is considered eligible if at least 2/3 of the approved membership of the Dissertational Council takes part in its work. There are 5 members of the Council, all of them are present, thus we have quorum. And the procedure of our meeting is the following. The duration of the meeting is no more than 2 hours. First, the chairman's summary report on the main content of the document submitted by the candidate and their compliance with the established requirements. Answers to possible questions, 5 minutes. Second, brief report of the candidate for the degree reflecting the main points of his research, up to 15 minutes. Questions to the candidate strictly according to his report, no more than 2 minutes for one questions, and responses of the candidate. Number 4, the speeches of all the members of the Thesis Council by turns with the reviews, with the statement of their positions, with the questions and suggestions to the candidates. No more than 10 minutes for the speaker. Number 5, the speech of the chairman with his review. Number 6, the answers of the candidate for the degree to the questions and remarks of the members of the Dissertation Council, no more than 15 minutes. Number 7, open discussion, speeches at the request of those present at the defense of the thesis of persons with a brief representation of their positions and or with specific questions and proposals to the candidate strictly on the topic of the research, no more than 5 minutes for each applicant. At the same time, all interested persons are requested to register in the registration sheet and, before submitting their speech, fully introduce themselves. First name, surname, scientific degree, place of work. Final answers of the applicant to the questions asked, no more than 5 minutes. The speech of the scientific supervisor, no more than 3 minutes. A 5-minute break before an open vote in order to make a conclusion on the issue of awarding or not awarding the academic degree of St. Petersburg State University to the candidate. For the time of the discussion of the defense results by the members of the Thesis Council, the broadcast is turned off. An open individual voting, counting of votes by the chairman of the Dissertational Council with entering the results in the minutes of the meeting. decision on awarding or not awarding the academic degree of St. Petersburg State University, the final word of the applicant, no more than 2 minutes. Before switching to the realization of the meeting's rules of the procedure, I remind you to switch off your mobile phones. Thank you for your attention. I also inform you that an audio and video recording of our meeting is being conducted, as well as the live broadcast on the website of St. Petersburg State University, and simultaneous interpretation of speeches from Russian into English or from English into Russian is also provided. Let me start the procedure of the meeting. First point, brief report of the chairman. The dissertation of Orlov Gerasim Nikolaevich for the candidate of law on specialty 120003 on the topic option contractual structures in the civil code of the Russian Federation and further development was accepted for the defense by the order of scientific secretary from the 17th of May. The thesis council was approved by the order of scientific secretary, and I have already introduced to you its board members. The candidate submitted the following documents to the scientific secretary: an application form addressed to the rector, Professor Kropotchev, about the acceptance for consideration and defense of the thesis submitted on the 6th of September 2018, the review of scientific supervisor Lebedev Konstantin Konstantinovich, the candidate of law, associate professor of the Department of Commercial Law of St. Petersburg State University, a list of publications including 3 papers outlining the main scientific results of the thesis, including 3 articles in peer-reviewed journals from higher attestation committee, certificates about successful passing of candidate exams from the 2nd of May 2015 issued by St. Petersburg's Institute of Foreign Economic Relations of Economics and Law, and certificate proving that our candidate successfully passed candidate exams on specialty 120003. Civil law, entrepreneur law, family law, international private law, history and philosophy of science, excellent, foreign language, English, good, and civil law, entrepreneur law, family law, international private law, satisfactory, and diploma with honors issued in the year of 2000 in the University of Tashkent, certifying that by the decision of State Attestation Commission from the 6th of April 2000, that our candidate received the qualification of lawyer. The thesis is done in Russian and English, both in paper-based version as a manuscript and in the electronic form. It should be noted that all listed documents comply with paragraph 12 of section 3, presentation and defense of dissertations, procedure for awarding academic degrees in St. Petersburg State University. And now, brief report of our candidate up to 15 minutes. Distinguished chairman and board members, dear guests, I would like to introduce to you the thesis on the topic option contractual structures in the civil code of the Russian Federation and further development as a result of the ongoing civil law reform and the adoption of federal law number 42, federal law of 8th of March 2015 on amending Part 1 of the Civil Code of the Russian Federation. Part 1 of the Civil Code of the Russian Federation was supplemented by legal definitions of 2 new contractual structures: an option to conclude a contract, Article 429.2 of the Civil Code of the Russian Federation and an option contract, Article 492.3 of the Civil Code of the Russian Federation. The importance of these contractual structures for building business ties in the field of entrepreneurship is difficult to overestimate. Nowadays, the potential of the option is currently not fully disclosed. The relevance of the study is due to the relatively narrow and underdeveloped mechanisms for using options in specific law enforcement practice, despite legal definitions of two optional contractual structures being consolidated in the Civil Code. The purpose of the research is the formation of holistic scientific concept of the option, which could serve as the basis for further improvement of the legal regulation of economic relations. The provisions are made for the defense, the totality of which allows us to characterize the option as a contractual institution and an element of obligatory legal relations. The place of optional contractual structures named in the Civil Code of the Russian Federation in the system of contracts is established. An option to conclude a contract and an option contract are an element of the obligation that defines the subject of the contract and allows the formation of a contractual obligation that can be fulfilled only if the creditor needs to fulfill it. An option to conclude a contract and an option contract are not independent types of contracts named in the Civil Code of the Russian Federation.
К возникновению основного обязательства. Однако законодатель называет...
In order to prevent confusion of concepts, legal forms are proposed, which the legislator named as an option contract and an option to conclude a contract, to call optional contractual construction, in contrast to those legal forms that, according to Part 2 of the Civil Code, are independent types or status of contracts. In order to ensure a common understanding in theory, as well as in law enforcement practice, the author's definition of an option as a generic concept interpreted as a contractual condition and the main element of a contractual obligation, in the exercise of which one subject of the option assumes the obligation to take certain additional actions, as well as to refrain from taking such actions or to suspend their performance for a certain period of time, and authorizes the other subject of the option to demand their fulfillment and thereby ensure their own unilateral expression or of will implementation of existing relations between the parties in a predetermined scope of rights and obligations. The option as a whole is proposed to the singled out into an independent type of obligation, identifying option contractual structures named in the Civil Code. It is determined that the optional contractual design has the duality of this subject subordinated to a single economic goal. Optional duty is the following. Articles 429.2 and 429.3 of the Civil Code of the Russian Federation to conclude optional contractual construction on a gratuitous basis. It does not mean the gratuitousness of the optional contractual construction, but prosecution by both parties of other goals and interests of a proprietary nature. To supplement Chapter 22 of this first Civil Code of the Russian Federation with Article 320.2 entitled Fulfillment of an Option Obligation as follows. From the moment of receipt of the demand for the fulfillment of the option obligation declared by the creditor or by a person authorized by the creditor, the debtor is obliged on conditions predetermined between the debtor and the creditor to perform the actions determined by the option obligation or to terminate the performance of the actions provided by the option, or to refrain from performance of actions provided by an option obligation. The debtor has the right to refuse to fulfill the option obligation if the creditor missed the deadline for the application of the option requirements established by agreement between the creditor and the debtor. By agreement between the creditor and the debtor, a time period may be set as provided for the debtor to make preparations for the fulfillment of the obligation defined by the option obligation. And to state paragraph 1 of Article 429.2 of the Civil Code in a new edition, by virtue of an agreement on the granting of an option to conclude a contract, one party shall grant the other party the right to conclude one or more contracts within a certain period of time on the terms and conditions provided for by the agreement on granting an option to conclude a contract. An agreement to provide an option to conclude a contract must contain all the essential conditions of the main contract. An option to conclude a contract is granted for a monetary reward or by virtue of the achievement of a certain economic goal, another counter-performance. To state paragraph 2 of Article 429.3 of the Civil Code of the Russian Federation in a different version, excluding the mention of gratuitous option contract. For granting the right to make a claim under an option contract, the authorized party is obliged to pay the debtor the amount stipulated by such contract unless the conclusion of the main contract is due to another obligation or other interest protected by law that arise from the relations of the parties. To supplement the 27th part of the First Civil Code of the Russian Federation with a new Article 421.4 entitled Exchange Options Agreement as follows. An exchange option agreement is an agreement of two or more persons according to which a creditor or creditors have the right to demand that the debtor or debtors perform the actions specified in the agreement by the contract, as well as pay cash if there is a difference in the prices or values of the underlying asset as determined by the contract. The basis asset of an exchange option agreement may be goods, securities, currency values, as well as circumstances, which the parties recognize as an in-stock exchange option contract as a basic asset. An exchange option agreement may not be included in any other exchange or off-exchange agreement. An exchange option agreement may be concluded exclusively at organized tenders between their participants, including those performing the functions of representatives and carrying out their activities on the basis of a license for an exchange intermediary or exchange broker. The provisions stipulated by these codes in the option obligation and the option contract shall apply to the exchange option contract unless otherwise provided by law, other legal acts, or the rules of the organizer of tenders adopted in the established manner. In this regard, the existing Article 429.4 the chapter of the 27th Civil Code, contract with execution on demand, shall be designated by number 429.5 of Civil Code as a chapter of the 27th Civil Code of the Russian Federation. The results of the dissertation research were discussed at the meeting of the Department of Commercial Law of St. Petersburg State University. Also, a number of provisions and conclusions of the dissertation research were reflected in the scientific articles by other authors which contain references to my works. For example, Zaripov, an option contract in civil law, Bulletin of Modern Studies, 2018, number 12. Dear Chairman, dear members of the Dissertation Council, dear President, the report is over. Thank you for your attention. Gerasim Nikolaevich, thank you very much. Distinguished board members, do you have any questions to our candidate? And everyone submitted his review, and I also submitted my review. If no one has questions, let us switch to the next stage of our defense. The announcement of the reviews of the board members. Olga Alexandrovna Makarova, please have the floor. Doctor of Law, distinguished guests, the topic of our research is very actual. All the provisions for the defense, conclusions and recommendations are very well explained. Provisions for the defense are very novel. The work, all the goals were achieved. The content of the research conforms with the tasks. The material is explained logically, and it proves the independence of the research, and the value of the work is explained by the analysis of the materials of court practice and analysis of all scientific works. At the same time, I have several remarks concerning the content of work. In the third provision for the defense, page 13 of the thesis, the author says that optional contractual construction has a dubious subject and subordinated to the unified economic goal. The subject of optional contractual structure is the fulfillment of one party and the fulfillment of the main obligation, but at the same time the author does not consider optional contractual construction and options are the types of legal measures. Then the obligations of one party appear in the condition of the claim, and the right of the other party is not corresponded by any responsibility. And the third remark, the type of the right of the claim within the frames of optional contractual structures does not prevent the right of the other party. These remarks are of precision character. They don't humiliate the research, and the discussional provisions for the defense prove the value of these provisions and show that the work conforms with the requirements of the scientific requirements, and the thesis itself conforms with the requirements and is an independent research, scientific research, which proves the tasks and which is very important for the development of the science and civil law. Olga Alexandrovna, thank you very much. I would like to draw your attention that the answers of our candidates will be heard after all the board members present their reviews. And as I saw on the website, the remarks intersect. And please, I kindly ask you to give complex answers to the remarks concerning the same problems. Then I would like to give the floor to Andreev Vladimir Konstantinovich, Doctor of Law, Russian University of Justice. Thank you. I read the dissertation of Gerasim Nikolaevich, and I came to a conclusion that a positive evaluation can be given to this research. The topic of the research is very actual. The conclusions are very logical. They are true and new. The author thinks that the amendments to the Civil Code, which were introduced on the 8th of March 2015 by our president, signed the laws on the Women's Day, and the general picture of optional structures, and it does not provide the full legal regulation. And the research of Gerasim Nikolaevich is that such application of optional structures helps that entrepreneurs to avoid risks or relieve these risks. And also in my written review, 5 new provisions are underlined. The research is very new in the respect that there were no scientific research, profound scientific research before, but nevertheless I have some remarks. There is specific novelty of the research, but my remarks are following. They are of discussional character and require supplementary explanation. At first, our candidate thinks that for me, I can't understand how optional structures and the conclusion of contracts and what's the difference between them, and how objective obligations can be formulated. Provision number 1. And have a question why such contractual obligation is different from optional deal. The second remark, the provisions for the defense show the interaction of optional agreement structure and option as independent types of obligations. There is a question, what is the dubious nature of the subject of agreement structure if they are aimed at the commitment? Number 3, the candidate our candidate says that economic goal of the parties of the optional agreement conforms with the civil contract stipulated by Article 423. But I think that these are different concepts. Then, the option on conclusion of the contract is the form of the refusal of one party from the realization of the principle of the freedom of agreement is a mistake. In accordance with the Article 421, the contract is signed independently by the parties and by their will, which is shown at this particular moment in the respect of the conditions of the main contract, except for the moment when the main contract came into force. The thesis is completed scientific work And I think that our candidate successfully concluded the problem of proportional correlation between optional contract structure, because this legal means has integrated economic purpose. And I advise you to include Ekaterina Abramovna Freitz among authors here. She offered subjective existing conditions. She started to work and taught at St. Petersburg State University, and I think that we should recommend our candidate for the degree, and the thesis conforms with the requirements of the order of the first vice rector. And our candidate deserves candidate degree. Thank you very much, Vladimir Konstantinovich. And now I would like to give the floor to Andreeva Lyubov Vasilyevna, Doctor of Law. Thank you very much. And I will try to be as brief as possible. The topic is very actual. Optional contracts were concluded before the amendments to the Civil Code of Federal Law 42, and legislator formulated general rules to new articles, and in fact there were no profound research before in this area, and the structure of the thesis, which includes 4 chapters, 12 paragraphs, it contains detailed analysis of the structures, and the author has the aim to reveal general features of these contractual structures, and he identified the place of these contracts, and he conducted the analysis on the basis of all views of pre-revolutionary and modern authors. At the same time, the author shows his own point of view. The conclusions of each chapter are logically developed in further provisions of the work, and this proves the artistic approach of the author to the topic of the thesis. The thesis has theoretical value and practical value as well, because in fact these structures allow to take into account economic interests of entrepreneurs and lower the risks when specific types of contracts are being concluded. And along with that, any scientific research has drawbacks, and some conclusions are of discussional character. At first, we should agree with the author that 2 structures are independent contractual structures, but they are similar in some parts. In my opinion, a supplementary explanation should be given concerning generic concept of the option which unites 2 contractual structures. In the thesis, he considered them as sub-institutes, page 13. Then, it is stated in the work that invalidity of any element of optional structure leads to invalid nature of the whole structure, and only transformation of the structure is possible into other type of contract. And the element here is considered as contractual condition. And in my opinion, if we correlate it with the concept of the deal and Article 180 of the civil law, that the invalidity of the part of the deal does not lead to the invalidity of its other part, and no condition of option is a considerable condition. And I can hardly agree with these conclusions. Of course, contractual structures involve being used using the conclusion of the contract with the participation of the entrepreneur. But the fact that they are of compensatory nature lead to the fact that in the civil court these norms are of dispositional nature. But in my practice I have the examples, and it would be better to use more examples which would show the application of these structures when separate types of contracts are being concluded. But my remarks of discussional character, and they don't influence the positive impression of the work. The thesis conforms with the requirements of the order of the first Vice-Rector of the University, Mr. Dementiv, and point 11 of this order was not violated by our candidate. And the conclusion is our candidate Orlov Gerasim Nikolaevich deserves the degree of the candidate of law on specialty 12003 civil law, commercial law, family law, private international law. Lyubov Vasilyevna, thank you very much for your review. And now I would like to give the floor to Suleimanov, Doctor of Law. Thank you very much. Distinguished Chairman, I'm not going to fall into details, and my review is similar to the ideas and to the review of my colleagues. All the questions have already been discussed, and on the whole, the research is very positive. And let me start with the drawbacks of the thesis. They are original. It is a very original scientific research. The thesis makes me argue with some points, with some ideas. The first remark is not negative, but it's rather positive one. As for judging from the name of the dissertation, our candidate explains optional contractual concepts. It is developed in Russia by Lebedev, Vitryansky, Karapetov, and other famous scientists. I would like to express my gratitude to the candidate for his thesis, because after reading it, I wrote an article on the topic of special contractual structures. When I read the thesis of Mr. Lebedev, I understood many things And as a result, I wrote an article, as I have already mentioned, which is named Special Optional Structures, General Agreements and their place in the system of law. The article comprises 25 pages. It was published. There is reference on the internet to my article. The main ideas, and I think that here there is some theoretical problem of general theory of civil law. And as for special contractual structures, there are 8 contracts: public, civil contract, framework contract, standard form contract, and so on. The candidate writes that optional contract is not from the category of separate contracts. They are of organizational character, but legislation names them organizational contracts, and special legislation norms are offered, and they should be named as optional contractual structures. The idea is very simple at first, from the first sight. These are contractual structures, but in further research we see that these contractual structures are contracts, offer contract clauses, failure to comply with the contract, and so on. I'm not going to be too detailed. I want to say that, in my opinion, the concept of legal structure is the norm and institute of law. Optional contracts should be in separate group. Should not be in separate group. They should go along with usual contracts. These are contracts which take place in the general part of obligatory law. In my article, I described everything in detail. I analyzed everything. I criticized this candidate, Vitryansky, Lebedev, and other scholars who develop this concept. And to my mind, it is wrong concept. The contract and the conclusion of contractual option, contractual structure, it involves the legal nature, which are stipulated by Article 429, and in those types of options which are not stipulated by civil law of the Russian Federation. The difference between two optional structures are in objective structure. Optional conclusion of agreements is the conclusion of agreements, and optional agreement involves the performance of the obligations. All these agreements, all these contracts are separate contracts. And at the same time, the optional conclusion of the agreement are aimed at the conclusion of the main contract, buy and sell contract, works contract, and the option contract is a type of main contract, such as contract of lease, buy and sell agreement, it has a separate burden in the type of option. And thus these are different contracts which can be attributed to the group of general agreements. I'm not going to dwell upon small faults or drawbacks. As for my remarks, they are connected with the research of fundamental problems of the theory of civil law, and here there are different interpretations are possible, and these remarks I think that the thesis of Orlov, Gerasim, Nikolaevich conforms with the main requirements stated by the order from the 1st of September of 2016 on the procedure of the awarding degrees at St. Petersburg State University, and our candidate deserves the degree of the candidate of law on specialty 12.0003.11 was not violated by our candidate. Thank you for your attention. And now I would like to give the floor to myself, the chairman's review. I studied the research of our candidate in detail. The topic of the research is very actual, and actuality is connected not with the fact that the norms of optional contracts which appeared in the civil code not long ago. This problem is connected with the fact that in law enforcement practice there is no integrated concept about optional structures, their place in the system of contracts they use. And here, in fact, the problem is very broad. And options, they are well known on financial markets, in the sphere of securities, and such generalizations of these institutions within the frames of civil code led to the necessity of their scientific interpretation. And Gerasim Nikolaevich decided to show in his thesis. The scientific provisions, conclusions, and recommendations which were formulated in the work are very well explained. They are proved by the analysis of regulatory acts. And our author defines and studies the set of legal norms, special literature, some discussion points are studies. The novelty of scientific provisions are reflected in the text of the thesis and proved by the widespread analysis of the problem. On the whole, I think that the work of Gerasim Nikolaevich is very successful and positive, and this I have some questions about the research. This thesis contains very important conclusions. The structure is logical and it conforms with the requirements. The work is very logical and the language of the text is on high level, but nevertheless I think that there are some questions which should be explained by our candidate. The first question is, in his work, Gerasim Nikolaevich Orlov speaks about some conditions defining the aim of contractual structures, the conditions of the agreements, the period of the claims which can be submitted, the conclusion of the agreement of some actions, and the order of the claims, the compensatory nature, And such approach of the author is generalized in the first and second provisions for the defense. Options of the conclusion of the contracts and optional contracts are not the types of contracts, they are contractual structures, and the author offered his own definition, but at the same time the author's position does not fully explain the idea of the civil code in the form of two articles, which is stipulated by the necessity of civil circulation. For example, the second is the contract where the performance of obligations is necessary. For example, civil contracts in the form of documents signed by both parties. You should explain the definition of optional contractual structures. Number two, the second provision, the fourth provision, the responsibilities, the moment, the definition of the moment of the conclusion of optional contracts connected with the will of the parties, page 115 of the thesis. The contract is concluded when the parties come to an agreement in terms of the conditions of the contract. The moment of the conclusion of the contract is the moment of the reception by the author who sent the offer, and the parties should express their will. The parties negotiate the clauses of the contract, and then they express their will. And whether it is the intention to create contractual relationships, but my remarks are of discussion character, and the thesis of Orlov, Gerasim, Nikolaevich is completed and independent scientific research containing scientific tasks which were successfully solved. The thesis of Orlov, Gerasim, Nikolaevich of the topic option contractual structures in the civil code of the Russian Federation and their further development confirms with the main requirements by the order from the 1st of September 2016 on awarding scientific degrees at St. Petersburg State University. The candidate Orlov Gerasim Nikolaevich deserved the degree of the candidate of legal sciences on specialty 12/0003, civil law, commercial law, family law, private international law. Dear colleagues, all the reviews have been announced, and I offer our candidate, according to the procedure of our meeting, to give his general comment to the questions of the board members, no more than 15 minutes, according to the agenda. Distinguished Chairman, distinguished board members, thank you very much for the opportunity given to me to be here today. The novelty of contractual relationships in the frames of contractual contracts are stipulated by unilaterality, and here is the main difference of options from the other contracts and contractual structures. And in this respect, the rights allow to create new segments of the market of out-stock optional requirements. And of course, the questions of board members and chairmen, of course, they are of theoretical value, but principal novelty of unilateral commitment is of discussional character, which is based on the fact that it is different from usual things. We got used to equal situation between the parties of the contract. First of all, I would like to answer the questions of the chairman, Doctor of Law, Petrov Dmitry Anatolievich. As for the first question, I would like to explain that contract institute of options can involve any contractual structure based on optional agreement structure aimed at optional contractual structure is aimed at the alteration of existing contractual conditions which were discussed in advance beforehand. And because of the tendency of the development of the Institute of Option, we speak about optional contractual structure, and here we see specific features of such option structures. Option contractual structure, legislator offer the choice of mechanism realization of subject law, which is necessary for the construction of flexible and universal connections, and it leads to the creation of mixed contracts. As for the second question, I would like to explain that the research, there is a conclusion that the moment of contract conclusion is the moment of the will of the parties, judging from the analysis of the Article 421 and 432 of Civil Code of the Russian Federation. It is explained on page 115 of the Thesis. The will of each party is reflected in the offer and accept, and if the will of the parties is the same, the difference between the will of the parties to conclude the contract and the analysis of these differences allow to conclude that the prerequisite to the contract conclusion is the will of the parties of the contract, and it is limited by a certain period of time within which the parties should negotiate all the existing conditions of the contract. The succession of point 1 of Article 434 of the Civil Code of the Russian Federation. As for the questions of the board member, Doctor of Law, Makarova Olga Alexandrovna, I would like to explain that the aims of the use of contractual option structures shown on page 62 of the thesis. The mechanism of realizations of subjective law, the main element of which is the interest of the right possessor. and optional contractual structures. The author considers such constructions as the legal measures of practical use. And predefined obligation. As for the second question, I would like to emphasize that the special obligations appear when the creditor give claims, and before that the obligations of the debtor are the part of contractual conditions. As for the question 3, I would like to draw your attention to the fact that the objects of civil rights are property rights. The norm of law does not say that the subjective law can't be able for circulation, and the rights for options on the conclusion of the contract can be given to the other person, and it supplements the main principles of the circulation of civil rights. And it does not depend on the general rule or other rules concerning this right circulation, the right to accept offer, and point 7 of Article 429.2 to accept offer allows to limit optional contractual structure of the paradigm, the circulation of the conclusion of the main contract, and they are aimed at the realization of the condition of the main contract. And as for the questions of the Doctor of Law, Andreev Vladimir Konstantinovich, as for the first question, I would like to emphasize that the main peculiarity of optional contractual obligation is the realization of optional contractual obligation subordinated to the right of creditor, and the requirement to the realization of optional contractual obligation and additional obligatory. They give the right of choice to the debtor, and such choice is subjective right of the debtor, but it is different because the creditor in optional obligation is not going to claim for realization. As for optional contract, the fulfillment of the debtor is not in place, and as for the deal, Article 157 of Civil Code of the Russian Federation does not stipulate, does not involve one of the parties. The parties discuss the moment of the rights and obligations because of the circumstances. And when such circumstance appears, a certain obligation appears within the frames of which the debtor has certain responsibilities. As for the second question, as in terms of the dynamics of realization, there are separate subjects of the fulfillment of the contract. And it is page 82 of the thesis. The subject of optional contractual structures and the subject of the main subject are interrelated. But we should take into account that in first case the subject is the creation and specific urgent right, and in the second case the shift of material and non-material assets. The same factor for the subjects is unified economic goal. As for the remark as for the fact that the fact concerning compensatory nature, the subject of entrepreneurship don't have the interests of their counter agent, which has specific value in the market, and economic effect from achieving of this aim the principle of compensatory nature with the help of the integrated economic goal is connected with the receiving of special material assets or competitive advantages in order to achieve economic goal. And as for the remark of Vladimir Konstantinovich Andreev about the fact that the provision concerning the options connected with the refuse of one of the parties connected with the freedom of contract, the fulfillment of responsibilities within the frames of the contract is provided not by the measure of property responsibility, by the way of the acceptance of special court act. And as for the conditions of the contract, the agreement about the provision of the option for the conclusion of the agreement. Thus, as for the responsibilities of the conclusion of the contract, the referent can't refuse from the conclusion of the contract, even if it is not profitable for him. Also, I would like to explain the remarks of Doctor of Legal Sciences Andreeva. Number one, the aim of the creation of the gender concept of optional. Every contractual structure. It is indicated on pages 85, 86 of the thesis. The definition of the gender concept of options will allow to implement regulatory norms of the Civil Code of the Russian Federation. And this approach will allow to decrease the number of new contracts which require legal regulation. The element in the context of paragraph 4.3 of the thesis, it is necessary to understand a set of existing conditions concerning the element of the agreement. As for the remarks concerning the provision about the exclusive compensatory nature of optional structures, I would like to draw your attention that the compensatory nature of agreements contradicts to the nature of entrepreneur activity. There is no aim to give the property right to contra-agents. And this provision is explained on page 43 of the thesis, and law enforcement practice follows this way. The economic goal allows to expand the scope of the implementation of options in entrepreneurs' aims. Also, the understanding of the compensatory nature of optional contractual structures allow to exclude the collision between Article 429.2, 29.3 and 575 of the Civil Code of the Russian Federation. As for remark about the necessity to use more examples in my research, I agree with this remark, with the opinion of the board member about the necessity of the wide spectrum of the examples of the application of optional contractual structures. There is little practice nowadays. It is being formed now. And as for remarks of the board member Mr. Suleimanov, as for the first question, I would like to emphasize that optional contractual structures can't be referred to separate contracts, according to my opinion, because the subject of optional obligation is dubious, and they don't allow to characterize these contractual structures as separate contracts. As for the remark concerning the second question, I would like to say that in fact this position is possible about the fact that the difference between the option on conclusion of a contract can be the main part in the understanding of the legal nature of these constructions. But optional contract and the conclusion of optional contract, they are not separate contracts. These peculiarities don't allow us to refer the conclusion of optional agreement and optional agreements to two separate types of contracts. Optional conclusion of contract and optional contracts are united by the fact that they are aimed at the construction of optional relationships, and it is individual feature which makes the difference between them, and it's no use referring the conclusion of optional contracts and optional contracts as separate types. Gerasim Nikolaevich, thank you very much. We are ahead of the agenda, but there is no problem. Our candidate gave all the answers And now open discussion. Speeches of those who are present at the defense of the thesis, but not including the dissertational counsel, no more than 5 minutes per person. Dear guests, do you want to ask questions to our candidates? There are no such questions. And now let us switch to this next stage. Speech of the scientific supervisor, Lebedev Konstantin Konstantinovich.
Уважаемый председатель, уважаемые члены диссертационного совета, уважаемые присутствующие. Я с большим удовлетворением выслушал выступления и ответы Герасима Николаевича и считаю, что состоялась оживленная, такая плодотворная дискуссия по проблемам, связанным с опционными договорными конструкциями. Очевидно, новизна вот этих договорных институтов, она будет вызывать и дальше дискуссии, предложения. Мы видим, что в литературе появляются все больше и больше публикаций, статей, и в основном статьи, они отдельные нюансы пытаются раскрыть и высказать по ним тоже собственную позицию. Очевидно, что вот сами представленные институты в Гражданском кодексе, положения вот названных статей, они не являются раз и навсегда завершенными.
Completed. And in the name of the thesis, there are such words as further development of such institutions in the civil law. I would like to draw your attention to the remark by a distinguished professor, Doctor of Legal Sciences, academician of the Academy of the Kazakhstan Academy of Sciences, Mr. Suleimanov, who underlined in his review, in his article, a very interesting article. I don't agree with all his provisions, but I would like to underline the accent towards organizational side, organizational part. We are based on traditional civilistics. We we are based on fundamental provisions on the science of civil law, which appeared before Soviet times, in Soviet times, and they exist nowadays in the USSR. Октябрь Alexeyevich Krasavchikov, professor of Sverdlovsky Law Institute of Law, he made attempts that these are not only contractual relationships, these are not only obligations including the responsible on fulfillment, that there are some organizational moments. The contracts organize relationships between parties. They organize the fulfillment of commitments, and by Dan Kontorich is right that these option contracts and conclusion of optional contracts, they contain organizational elements, and they are very important for the practice. And here I don't agree that the name of distinguished Vladimir Vetryansky was not mentioned, one of the authors of the concept of the improvement of civil law. In his work about the reform of the civil law, he did not agree with the concept of the structure of option contract. In his opinion, such a contract does not exist. I don't agree with this idea, because unlike typical classical optional institutes, the law contains organizational moment. And you supported your candidate. Thank you very much for that. Distinguished colleagues, according to our agenda, we switch to the other part of our meeting, discussion by members of the Council of the issues of awarding a scientific degree, a 5-minute break. I ask you to turn off the sound during the broadcast of the meeting. Guests and not board members, please leave the hall. I will invite you when our consultation meeting is over. Thank you very much for understanding.
Коллеги из технического коллеги из технической службы, можно включить?
The meeting continues. I ask you to switch on the sound of the meeting's broadcast to make sure that it is working. The conclusive minutes of the Dissertational Council's meeting are coming. I raise the question of awarding an academic degree to an open roll call. I remind you that the decision of the Dissertation Council on the issue of the awarding the degree is considered positive if more than half of it voted for, but not less than 3 members of the Dissertational Council who participated in the meeting, in accordance with paragraph 23 of the procedure for awarding academic degrees in St. Petersburg State University. Makarova Olga Alexandrovna, your opinion. Distinguished members, dear guests, I think that our candidate Orlov Gerasim Nikolaevich deserves the degree of candidate of legal sciences on specialty 120003, civil law, commercial law, family law, private international law. Thank you very much. Andreev Vladimir Konstantinovich, your opinion, please. I think that Gerasim Nikolaevich deserves the degree of candidate of legal sciences on specialty 120003, civil law, commercial law, family law, private international law. Thank you very much. Andreeva Lyubov Vasilyevna, your opinion. I am for the degree of candidate of legal sciences on specialty 120003, civil law, commercial law, family law, private international law. Suleimanov Maidan Kontarovich, your opinion. I am for the awarding of the degree of candidate of legal sciences on specialty 120003. Thank you very much. And my own opinion as a chairman of our dissertation council, I am for the awarding of the degree to Orlov Gerasim Nikolaevich on specialty 120003. Thus, distinguished members, 5 board members were asked. Everyone was agree with the awarding of the degree. Out of 5 members of the council, 5 members voted for. There were no one who voted against and who was abstained. Decision on awarding the academic degree of the candidate of legal sciences on specialty 120003, civil law, commercial law, family law, private international law was accepted according to the agenda. Now, the final word of the candidate, 2 minutes. Distinguished board members, distinguished chairman, I would like to express my gratitude to you for such high evaluation estimation on my thesis. Thank you very much. And I would like to express my gratitude to my scientific supervisor, Konstantin Konstantinovich. Without your support, without your supervision, which disciplined me, I could not stand here. Thank you very much. Gerasim Nikolaevich, thank you very much. And the meeting is declared closed. Thank you all for participation. Thank you. Please switch off the live broadcast of the meeting.